that those are calls and contacts with Rusty. That's really not anything that you can testify to. Is that right?
Correct.
Okay. And that's defense exhibit number 51. Same would be true, I guess, for defense exhibit number 52.
Since this
You
is a
talk
summary,
about
yes, ma'am.
contacts with Rusty, the same problems that we just talked about. It could be the defendant calling home, talking to her daughter, right?
This is a summary of the other screen, so yes, ma'am.
Okay, and it could be the defendant calling home and talking to the nanny, right? You counted that as a contact with Rusty?
That is correct.
And we're now acknowledging that that's really not something that you know or can testify to. Is that right?
I will say yes, and may I qualify that?
Yes, you may, well, you can explain your answer. Yes, sir.
Thank you. The same would be true for anyone's cell phone. I don't know who was talking on your phone, so therefore any contact from your phone wouldn't necessarily be from you either.
Well, that's fair enough, and let's talk about that. Do you have your cell phone on you now? Or
I
did you
do.
have it when you walked into the courtroom?
I do.
Okay. And if an individual carries around a personal cell phone and is generally the person who has and uses that cell phone, is it a safer assumption that that person is in fact the person who answers the calls and makes the calls that show up on the cell phone records that you reviewed?
Absolutely. It's an assumption.
As opposed to a landline phone. Is it your understanding, or would you assume that anyone living in the household would have access to making calls and receiving calls on a landline phone?
That's an assumption
In
that can be
normal
made. Yes, ma'am.
circumstances? Okay. Now, I want to ask you about your slide, defense exhibit number 53. Now, you talked about defense exhibit number 53, an October 22nd trip to Greenville, South Carolina. Do you remember your testimony about that?
Yes, ma'am.
Were you aware that that was actually an overnight trip? It was the 21st and the 22nd of October 2010.
No,
Were you
ma'am.
aware of that?
No, ma'am.
Okay, so in your analysis, nobody asked you about the 21st of October 2010.
That is correct.
You just talked about one day of the two-day trip.
Correct.
That's right? Okay. I believe you testified similarly about an August trip to Greenville, South Carolina. You provided some testimony about August 27th? I'm sorry, here, let me put up defense exhibit number 54. Defense exhibit number 54, again, the first part of that slide, there are no calls between Melanie White and Hemi Newman during the October 22nd, 2010 Greenville trip. I want to ask you a couple questions about that. We now know that that was an overnight trip, so it was actually the 21st and the 22nd. Is that right? Assume for me that this was an overnight trip, that the evidence has already been established that that was a trip that was taken on the 21st and the 22nd of 2010. Your information on defense exhibit number 54 doesn't reflect any contact on October 21st. Is that right?
Yes, ma'am.
Okay, so that's only one of the two-day trips, or one day of the two-day trip. Is that right?
Assuming what you just told me is true, yes.
Okay, and you looked at Melanie White's cell phone records, is that right? I'm sorry, you identified Melanie White, as you did in slide number 54, by the cell phone number that you were provided for her, is that right?
Looking at Hemi Newman's phone records, yes, ma'am.
Okay, what about her home phone?
No, ma'am. Did not look at that.
Okay, so if you are now made aware that Ms. White testified to this jury that some of her contact with Hemi Newman occurred while she was using her home phone or her landline phone, that's not showing up in your contact here, right?
That would be correct.
Okay. Let's go to the second point that you have on there, the August 26, 2010 Greenville trip. Are you aware, or were you aware when you put together this slide that too was an overnight trip? That was a trip that occurred on August 26 through August 27, 2010. Were you aware of that?
No, ma'am.
Okay, so if in fact that's true, and let's assume for the purposes of my question that it is, your information here, that would be incorrect for the entirety of that Greenville trip. Is that right?
I need you to rephrase, please. I'm sorry.
Well, let me say this. If there were calls on August 27th, 2010 from Greenville, from Mr. Newman's phone to Melanie White's phone, that information wouldn't be included on your slide here. Is that right?
That is correct.
Okay, so you don't have any information about the calls that were made between Melanie White and Hemi Newman on August 27th, 2010.
That is correct.
Okay. And again, the only Melanie White phone number you had was her cell phone. Is that is what was identified to you, right?
Correct.
All right. So if any contacts occur between Hemi Newman and Melanie White while she was using her landline phone, as she testified to this jury, that wouldn't be included on your slide either.
That's correct.
Okay. You couldn't retrieve any deleted phone messages, the content of any deleted text messages from the defendant's BlackBerry phone for November 18, 2010. Is that right?
That is correct.
Okay. You know they were made, right? You know there were text messages between Hemi Newman and Andrea Sneiderman. You know that from the phone records, correct?
That is correct.
And you, in your analysis, you weren't able to retrieve the content of those text messages either, were you?
That is correct.
All right. Mr. Broom, you also testified about the data usage. Do you recall that testimony?
I do.
You recall testifying that you used not the cell phone, the actual phone call information per the phone records that you reviewed, and not the information that you received from the text messages from the cell phones that you reviewed. You testified that you used the data usage from the AT&T information in order to put Mr. Newman in a location somewhat south of Longmont, Colorado. Do you remember that?
Yes, ma'am, I do.
You're aware, aren't you, of the problems of the unreliability of the AT&T data usage information as far as you're able to map a location using that information? You're aware of the difficulty they've had in that, haven't you?
I am aware, and I have a follow-up.
Listen to my questions, please, and answer my questions. You're aware that there's problems, right?
I am aware, yes.
Okay, and you're aware that the FBI won't use that information in order to establish a general geographic location for anybody because it's just unreliable. You're aware of that, right?
I am aware, and I have a follow-up.
Please answer my questions.
Your Honor, I'm going to object. I think he's using the word follow-up, and I think that's clear.
Well, now, that's the term I'm hearing, Mr. Now. You're going to interpret his word?
Yes, sir, I think he's trying to explain his answer.
Well, now, I understand what you're saying, Mr. Petrie, and I will allow him to explain any answer, but he's using the term he has a follow-up. So your objection is
But
what?
he's trying to explain his answer, and she's moving on to the next question before allowing him to.
My question is whether he is aware of something.
Well, I understand that. Yes, Mr. Petrie, yes, Mr. Petrie, you're making the objection that he's using the term follow-up and he should be using to explain his answer.
I think whether or not he's using the vernacular that we use in this courtroom, he is attempting to explain his answer, and he is allowed to do so.
Let me say this as clear as I can, Mr. Petrie. He's always allowed to, explain his answer. So if you want him to explain his answer, I will allow that.
Right.
So, sir, if you need to explain your answer, you may explain your answer, but that's not what he was relaying as far as the words he was using.
I understand.
But you can explain your answer. Yes, sir.
Thank you, Your Honor.
You're aware, right, that the FBI doesn't consider the data usage information reliable for purposes of providing a geographic location. You're aware of that, right?
Except the way you're phrasing the question is incorrect. They do use it to establish geographical location, meaning a state, a county. They don't establish it to establish a precise location.
Like you were trying to do.
No, ma'am. I was trying to use an investigative tool to show me an area. I was not trying to place somebody in any area. I was trying to expand my investigation. Just like when you conduct any investigation, you start with the broad and you work your way in. I had a tool of, I'm still explaining my answer, ma'am.
Time out. Counsel, don't cut him off. He's allowed to explain his answer. If you have an objection that he's going beyond that, I'll listen to
I
the
do,
objection.
Your Honor. I
Don't
think
cut him
the
off.
witness's answer is non-responsive to the question.
Sir, you are allowed to answer the question. You may explain the answer.
Yes, sir.
All right?
Yes, sir.
So now, have you completed the explanation of her last question?
Yes, sir.
All right.
All right, and using that unreliable information, you sought to obtain any hotel records that you could for Hemi Newman in that location, right?
Except the information wasn't unreliable.
Right. You
It
brought
got me
all
to the
of-
area.
Excuse me. You brought all of your skills.
Time out. If the question, Mr. Daniels, calls for a yes or no answer, yes or no, then you can explain.
Understood, sir.
All right. Next question.
You attempted to find hotel records, is that right?
That is correct.
You were unsuccessful in doing that. Is that
Correct.
right? You brought all of your skills as a private investigator to bear, correct?
Yes, ma'am.
All right. And you were unable to locate any hotel records or get any information indicating that Hemi Newman was registered at a hotel anywhere in the Longmont, Colorado area in July of 2010. Is that right?
When I looked at it 3 years later, yes, ma'am.
All right. Mr. Broom, you're being paid for your services, correct?
My lab was compensated for our time to conduct investigation, and yes, I'm being compensated for my time.
And can you approximate for the jury, please, how much compensation has your firm obtained or billed as a result of your testimony? I'm sorry, and the work you've done on this case?
Certainly. The examination that we conducted of multiple cell phones, computer devices in the case, and the private investigation work we've done all amounted to approximately $40,000.
$40,000?
Yes, ma'am.
Thank you, Mr. Broom.
Any additional questions? Ms. Cross, any additional questions?
No, sir.
All
Thank
right. Mr. Petrie, you may redirect if you wish.
Just very briefly.
Oh, ask as many as you wish.
Just got a few. Mr. Broom, even though you did not testify about the other analysis in this case, can you tell the ladies and gentlemen of the jury in the court what other work your firm did, other digital forensic work other than the BlackBerry itself? What other devices or information did you review?
Certainly. We examined a forensics image of a GE computer belonging to Mr. Newman, a GE computer belonging to Mrs. Sneiderman, Rusty's cell phone, Mr. Newman's cell phone, Ms. Sneiderman's BlackBerry device, another iPhone for Andrea Lippman, I believe, and I believe that's the extent, oh, and the AT&T call records that we had to review, which were quite extensive.
And
I believe they're here.
even though the results of the other analyses are not here in this case, before this jury, did you in fact have to do the same full digital forensic examination of all these other devices?
Oh, yes, sir. And when you do that for a,
Deputy, if you would assist me, I apologize, Mr. Petrie. Would you secure that phone, Mr. Deputy? I apologize for the interruption, lawyers. You may continue,
Thank
sir.
you. And you have to charge, or you charge for the work you do whether or not you end up having to testify about it, is that correct?
yes, sir.
Okay. That's all I have, Your Honor.
Any read, direct?
No, sir.
Lawyers, may this witness be released and excused, Mr. Subpoena? Mr. Petrie?
No objection from the defense, Your Honor.
No objection, Your Honor.
Yes, sir, you're free to go.
Thanks, sir.
Thank you. Have a good day.
Thank you.
Drive safely. Call your next witness. Mr. Clegg, we're,
Yes, sir.
all right.
Yes.
Ladies and gentlemen, I need, with the assistance of Deputy Garrett, I need you to step into the jury room a moment, please. Thank you very much for your patience. All right, lawyers and parties, you may be seated. All right, Mr. Clegg, are we at that point?
Yes, we are, in fact, Your Honor.
All right. Mr. Clegg, Mrs. Sneiderman, would you stand, please? Mrs. Sneiderman, I mentioned to you the other day, let's do it this way. Would you raise your right hand, please? You solemnly swear or affirm that the evidence you're going to provide the truth, so help you God?
Yes.
You may lower your hand. State your full name for the record.
Andrea Sneiderman.
Mrs. Sneiderman, you're on trial in this particular case, indictment number 13-CR-2413, State of Georgia versus Andrea Sneiderman, charged with various offenses. You have a right to testify on your own behalf. It is your decision on whether or not you want to exercise your right to testify during the course of this trial. If you exercise your right to testify, you will take the witness stand, you'll be sworn in by Deputy Garrett, and you'll be subject to examination by your lawyers and also any lawyer by the state. But it's completely your decision on whether or not you want to exercise your right to testify. Your lawyer had indicated the other day that he wanted me to wait until, quote unquote, near the end of the defense case, and that's, to my understanding, based on Mr. Clegg's indication, that's where we are. Have you made a decision on whether or not you want to exercise your right to testify?
I have, Your Honor.
And do you want to exercise your right to testify?
No, sir.
Do you need any additional time to consult with any of your four lawyers?
No, I do not.
At this point in time, do you want to exercise your right to testify?
No, I do not.
All right, that's fine. Thank you. You may be seated.
Thank you.
Mr. Clegg, are there any other witnesses at this point in time?
No, Your Honor, we will be resting subject to confirming that we have tendered all of the evidence that we sought to tender or sought to admit during the course of the trial.
All right.
But we will have no other evidence.
All right, Mr. Clegg, what I would like to be able to do before I bring the jury out, and you do that in the presence of the jury, would you consult with Kelly Carpenter and court reporter and see if those items have been omitted at this time, so when I bring them out, you'll be able to. And while he's doing that, I will ask, is there going to be, get more information, or is there going to be any rebuttal from the state?
If Your Honor could give me a quick minute. Just
Oh, do you have time? That's fine.
Yes,
I'll
sir.
wait. I'll wait to ask you that.
Jeff Hollinger back with Zara Karanchak, our attorney who is with us today. So the word has come forth. If there was any doubt, any questions, any speculation, let it go away, because Andrea Sneiderman will not be testifying at this trial.
That's right, and I think that's a smart decision on her part.
We're back on the record. Mr. Clegg, have you and the other boards
Because
had a chance to consult with Ms.
I
Carter?
think they have done, what they can do as far as a defense. And again, the prosecution has the burden of proof. If she were to take the witness stand, we've seen that the prosecutors are effective at cross-examining the witnesses and poking holes in their stories. So it would be very dangerous to do that.
All right, thank you, Zara. Let's go back now. Here's Tom Clegg in front of Judge Adams.
56A and 56B?
Yes, Your Honor.
Any objection from the state to 56A and 56B?
No, Your Honor.
All right.
Otherwise, Judge, we're good.
All right, thank you. Mr. James, have you had an opportunity, before I bring the jury out, on whether or not at this point in time you're going to have rebuttal evidence?
I have, and there will be no rebuttal evidence, Your Honor.
All right. At this point in time, lawyers, what I will do is bring out the ladies and gentlemen of the jury and have the defense rest in the presence of the jury,
Yes,
and
sir.
then we will take up those matters that we will have to take up requiring the conclusion of the charge conference.
Yes, sir.
All right. Deputy Garrett, if you would, please. Lawyers, Ms. Carpenter has brought to my attention, apparently it's three. It's actually 56, 56 alpha, 56B. Is there any objection to any three of those discs from the state?
56A,
Well,
56B.
It's 56, 56A, and 56B. Should be three. I had mentioned two, but actually there are three items.
Yeah.
We'll deal with it.
Yeah.
Yep, that's fine. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. You may be seated in any seat. Yes, we have one seat open at the end for you. That's fine, come on down. Lawyers and parties, you may be seated. All right, Mr. Clegg, you may proceed, sir.
Your Honor, at this time, the defense would rest.
All right. All right, ladies and gentlemen, at this point in time, the defense has also rested. The state rested earlier. At this point in time, I will ask the state, is there any rebuttal evidence to be presented?
No, Your Honor.
All right. At this point in time, ladies and gentlemen, both the state and defense has rested its case as far as the presentation of evidence of the proceeding has concluded. The next phase of the proceeding will be what is called closing arguments. But I need to take up a matter outside of your presence and discuss some issues with the lawyers before they do concluding remarks. Both the state and defense will have an opportunity to give closing arguments, and they have up to 1 hour each to do that. So I just have to take up some other matters. Let me just briefly, because what's going to end up happening from a practical standpoint, instead of having you sit there in the jury room, I'm going to make a different decision and bring you back at a certain time. But I just need to confer with the lawyers to see what time I'm going to bring you back. Okay? Now, and I will give you those instructions at that point in time. And I can go ahead and give you some of those instructions right now. And when I do release you, although we are not there yet, you still have to keep an open mind and listen to all the arguments and the law that I will provide you. But when I do release you, do not discuss the case or allow anyone to discuss the case with you. And when I do release you, I will need you, my preference is for you to leave the fifth floor, so you won't interact with anyone you should not interact with. If you do decide to have a meal or whatever during this break, just don't let anyone sit next to you or to discuss the case, or sit near anyone who may be discussing the case. You're going to have to either ask them to move or move away from you. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog about this case while it is ongoing, and it is still ongoing. Do not go to any location or typically go to any location that may have been made reference to. At this point in time, the presentation of evidence phase has concluded, and you will have the various components with you at the appropriate time, but you are not to discuss the case or start deliberating at this point in time. When I do release you from the building, you're more than welcome to bring something to snack on or eat with you for the afternoon session. Do not consume any alcoholic beverages during lunch, and the deputy will provide you with your cell phones, text phones, smartphones, and communication devices at the appropriate time. But even if you check your messages, do not receive messages, either text or verbal, about this case, or do not send any about this case. And you've been great up to this point in following the court's instructions. As I indicated, the lawyers and the parties cannot talk or interact with you, so I don't ever want you to think they're being rude or discourteous. I'm just going to briefly have the lawyers approach. I'm trying to coordinate some things for this break. And when you do return, we will be going into, when I say we, the lawyers will have an opportunity to give you closing arguments. After the arguments have concluded, I will tell you the law that will be used in this particular case. Then the evidence will be given to you, and you will start your deliberation at that point in time, but not right now. All right, I'm just giving you this preliminary. So if you could, just sit there very patiently, all right, while the lawyers approach. Lawyers approach.
Jeff Hullinger back with Zara Karinchak, our attorney who is with us. So this we know, the defense has rested. There will be no rebuttal from the state. We are now ready, willing and able to hear the closing arguments. As you heard from Judge Adams, will be approximately an hour in length. Each side has that ability. Will that happen today? I think we have kind of speculated that tomorrow would be closing arguments, but listening to the judge, Zara, it would seem to me that today is going to be the day.
You're right, and I'm kind of surprised by that. But this judge is serious, and he wants to keep it moving, and he's very cognizant of the jurors' time. And we've got plenty of time. It's 11:10, so we've got till 5 o'clock. And he also mentioned they're going to do the jury conference and get their jury charges down, and there may be some discussions of those.
And what does that mean?
Well, basically the law that's going to be charged to the jury, and each side submits what they would like to be presented to the jury, and the judge decides which jury instructions will be given. A lot of folks underestimate the importance of the jury charge because it's very mundane law, but it's important because it instructs the jurors what they should be listening for and paying attention to, and what they're going to use to make their decision when they go back to render their verdict. And so it's actually a critical phase when the lawyers are fighting about what words are going to be said to the jury.
Here is a question for you, and I don't think you can answer it, but I'll ask it anyway. How long do you think a jury will be out with something like this?
You know, I am never right on that.
All right.
I'm never right.
All right, counsel, I will retract my question then. All right, let's go back into the courtroom. We'll have more with Zara Karinchak as we get ready for the lunch break, which should happen within about 40 minutes.
I'm going to change the schedule a little bit, which is wonderful. Change is good. Okay. I'm going to bring you back, instead of my normal time at 1:30, we're going to change that just a little bit. I'm going to bring you back at 1 o'clock. Okay. It still gives you time to do what you need to do, but it also gives me time to do what I need to do with the lawyers and the parties. Okay. Now, those instructions that I gave you, let me just make sure we're on the same page. I know you just heard me give them to you a minute ago, but I just want to make sure we're clear. Because we are clear. Do not discuss the case or allow anyone to discuss the case with, even if you decide to go to lunch, because I know as time goes on, people go to lunch, which is okay. But don't go to lunch right now talking about this case. Do not remain upon the floor. Do not go on the internet. Do not look at any media coverage. Do not talk to any reporters, give any interviews pertaining to this case. Do not go to any location that may have been made reference to. Do not blog about this case while it's ongoing. Do not go to any location that may have been made reference to. All the evidence has been presented at this point in time and is closed. As I said, the next phase of the proceeding when you return will be closing arguments, and I will give you the law that applies to this particular case. And then at that point only will you start actually deliberation. You're going to check your message and everything at this point in time. The lawyers and parties cannot talk with you outside the presence of the court. I don't ever want you to think they're being rude or discourteous. All right? What I'm going to do is release you, and I want you physically back in the jury room at 1 o'clock. 1 o'clock. 1 o'clock. It's a little bit different, which is okay. Change is good. But 1 o'clock. 1 o'clock. And the reason I'm repeating that because I know we're all creatures of habit. 1 o'clock is going to be a real time. 1 o'clock. Any questions about logistics? Wonderful. Hearing none, follow the instructions of Deputy Garrett. Take your notepads and leave them there in the jury room, and I'll see you back at 1 o'clock. 1 o'clock. 1 o'clock. It's an early lunch for you, but 1 o'clock. You don't have to eat, but just be back at 1 o'clock. Just leave your notepads there, turn them face down. Nobody's going to look at your notes but you. I'll see you back at 1 o'clock. Lawyers and parties, you may be seated. And lawyers, as soon as the door closes, we're going to go back on the record, Kelly. The lawyers need a break before we go on the record. Wonderful. Hearing no one needing a break. All right. Let's go ahead and conclude the charge conference at this point in time. Yes, Mr. Jones.
Your Honor, may I be excused? My co-counsels are going to handle the charge conference with myself and Mr. Pasquale.
Yes, sir. You may.
Yes, sir.
Your Honor, before we proceed with the charge conference, we'd like to make a motion to...
Oh, I'm sorry. I apologize. Yes, sir. I'm sorry.
We have...
Oh, yeah, yes, sir. Yes, sir. Yes, sir. Oh, yes, sir. Yes, sir. I'm not prohibiting anyone. Yes, sir. Yes, sir.
Your Honor, just respectfully, now that the state has closed its case, we would like to renew our motion for a directed verdict on all the grounds we previously raised. I will not repeat all the oral arguments we previously made, just like the record to reflect that it has in fact been renewed. I would like to bring your attention, Your Honor, only to 2 points. The first is that...
You're not limited. You can bring up as many points as you want.
I don't want to waste the court's time repeating everything we said previously, but there are 2 things I think that are very clear and would be important to assess at this time. The evidentiary rule for perjury cases requires the testimony of at least 2 witnesses to establish the falsity of a fact. In this case, the state had confirmed in our previous argument that with respect to the charge that Andrea Sneiderman lied when she said that she did not know prior to her arrival at Dunwoody Prep that Rusty Sneiderman had been shot. The sole evidence that the state has on that issue, on that charge, is the testimony of Donald Sneiderman. It is uncorroborated by anything. There is no other evidence submitted in this record that establishes that knowledge prior to the arrival at Dunwoody Prep. As a matter of law, the court has to rule on that issue before it submits it to the jury. We respectfully submit there is no such corroboration and that charge should clearly be dismissed.
And you're speaking only to count 4 for right now?
I'm speaking, I believe it's count 9, Your Honor. It's the perjury charge on the same issue.
Well, count, yes, sir, the perjury count.
That allegation effectively arises in 2 places. They've made a false statement count with respect to it. They have made a perjury count with respect to basically the same thing.
Right. Count 4 is a perjury count. That's how I sort of...
Is it? Then I apologize, Your Honor. I didn't bring up the end of it.
I was just making sure we're on the same page.
Yes, sir.
And
That would be the count.
also perjury. Now, count 9, because I know the numbers change. You may want to take a look at your indictment.
Yes, sir.
I shouldn't say they changed, but because certain counts were dismissed. Count 9 is a perjury pertaining to wit that she did not share a hotel room with Henry Newman in Longmont, Colorado, such statement being material to the issue surrounding the murder of Russell Sneiderman. Now, count 4 is a perjury count pertaining to wit that she did not have knowledge that Russell Sneiderman had been shot at the time she spoke with Donald Sneiderman prior to her arrival at Dunwoody Prep, such statement being material to the issue surrounding the murder of Russell Sneiderman. That was count 4.
Yes, sir. I'm talking about count 4.
Okay.
Yes, sir. And under the new indictment, or the renumbered indictment after the previous charges were dismissed, I'm talking about count 4, the perjury charge on that issue.
Yes, sir. That's what I was saying.
Yes, sir.
And you had another point?
The same thing applies to the count that references the alleged kiss in Greenville, South Carolina. And that is would be now count 12, Your Honor.
Yes, sir. I have count 12 marked also.
There is no testimony in the record establishing whether or not that kiss took place in Greenville, South Carolina, other than the evidence of the oral testimony of Christine Oliveira, the waitress. In the absence of corroboration of that kiss, as a matter of law, that is insufficient to go to the jury. Okay. Your Honor, I'd like just the record to reflect that, plus that we've renewed our motion for directed verdict on the same grounds that we previously argued, sir.
Who's going to address this issue?
I will, Your Honor.
All right, Ms. Cross, if you could specifically address the issues he's
I will, Your Honor. I will, Your Honor. I think that is just to say that there are 2 witnesses required to corroborate a charge of perjury is just a misstatement of the law. 2 witnesses are not required. The 1 witness is not sufficient. However, there has to be corroboration, and corroboration can take the form of a 2nd witness, or corroboration can take the form of any other circumstantial or direct evidence tending to prove the count. Count 4, the reference to Donald Sneiderman. Donald Sneiderman testified in that in a direct way about his conversation with Andrea Sneiderman, and that would provide a basis for the count of perjury in corroboration of Donald Snyder's testimony was the phone records indicating that at the time the phone call was made, first of all, it established that a call was made, established the duration of the call, it established the location of the defendant's phone when she made that call, and it was prior to the time that she arrived at the daycare and could have been told that her husband had been shot. So those corroborating circumstances corroborate the testimony of a single witness, and I'll refer the case to the Dixon, I'll refer the court to the Dixon case that we discussed when this topic came up during the directed verdict motion. The sufficiency of the corroboration is an issue for the jury to determine. There's certainly enough to provide the state with a sufficient basis to get it past the directed verdict. We've done that. The court's already ruled on it, and there's no reason, the defense gives this court no reason to change that ruling. The second charge that is...
Count 12.
Thank you. Count 12, yes, the perjury. That the defendant lied on the stand under oath when she testified that she did not kiss Hemi Lumen while in Greenville, South Carolina. The testimony of Christina Oliveira was that, in fact, she witnessed this event. The corroborating circumstances surrounding that were the receipt indicating that Hemi Newman and Andrea Sneiderman were at that restaurant on that day, the cell phone records that corroborate Ms. Oliveira's account that during the period of time when the defendant was in her restaurant or her bar, her dance club, that she received a call and became upset. There are phone records that corroborate the fact that the defendant received or made a call to Rusty Sneiderman during the time period that Ms. Oliveira testified that they were in the restaurant. She's identified the defendant as being there. She's identified Hemi Newman as being there. And the email communication between the defendant and Hemi Newman in the days after the second Greenville, South Carolina trip corroborate that, in fact, something happened that made the defendant feel angry, upset. She had desire versus reality, conflicting feelings, things like that tend to corroborate the testimony of Christina Oliveira. For those reasons, the state has made, as a matter of law, a sufficient showing that those 2 counts of perjury, as well as all the other counts of the indictment, should go to the jury, and we'd ask the court to deny the defense motion.
Anything else, Mr. Chalmers?
Your Honor, yes, I respond briefly to both.
Oh, you may.
On the first point, the law does in fact clearly state in the evidence code that when a conviction is sought to be premised for perjury on the oral testimony of a witness, it must be corroborated by independent, strongly corroborative evidence. In this case, the state is bootstrapping. They're essentially arguing that the corroboration of what Donald Sneiderman said, Andrea Sneiderman said, is the fact that the phone call occurred and the phone records show that it occurred. That is not evidence corroborating his assertion of what was said. Remember, the 2-witness rule goes to the alleged falsity of the statement. In order to prove that Andrea Sneiderman lied about what was said in that phone call, they have to come up with 2 witnesses to prove that, or 1 witness, which they have, Donald Sneiderman, plus corroborating evidence. There is no corroboration in this record of what that occurred in that phone call. The cases are very clear. You may not convict somebody for perjury based on oral testimony versus oral testimony. That's all we have here. With respect to the second issue about the kiss, the law is very clear that the corroborating evidence must be independent of the testifying witness. The records that were introduced from the Pulse restaurant came from Christina Oliveira. She participated in preparing those records. That is not independent corroboration of her testimony that a kiss occurred. It must be independent. Case law is very clear of that. In addition, the fact that the records show that they were there does not show that there was a kiss. In this case, the state has alleged that the defendant lied about whether there was a kiss. This is what we've spent our summer on. That issue has to be corroborated by some other testimony. There is no email that references a kiss. There is no testimony of another witness saying, yes, in fact, there was a kiss. As a matter of law, on those 2 counts, the state has failed to meet its burden of proof, Your Honor. Thanks, sir.
Mr. Chalmers and Ms. Cross, at this point in time, I'm going to deny the motion for the directed verdict as to count 4 and 12, and saying that there may be slight corroboration, but the jury's going to make the ultimate decision. So both counts 12 and 4 will continue to go forward at this point in time, exceptions noted. Mr. Clegg, you needed something else for the record before we did the charge conference?
Can't say that I do, sir, no. I'm unaware of what it is that I need to place on the record. No, sir, I do not believe there's anything else I need to place on the record.
All right, that's fine then. Let's complete the charge conference. Lawyers, what was discussed yesterday evening, that was an initial interaction and conversation pertaining to the proposed request for charges. Yesterday, we started with Mr. Petrie and Ms. Cross, or anyone else wants to interact. I had indicated what was going to be provided. There was a couple items on the, we're going to start with the state, Mr. Petrie, and you'll respond first, followed by Ms. Cross. On number 10, requests, Mr. Petrie, it was the evidence charge. It is meant to be tailored specifically for this particular case, Mr. Petrie. Any particular language you're objecting to, Mr. Petrie?
And you're talking about the state's request?
Yes, I'm at states.
Oh, I'm sorry.
So I'm looking for your objections, because I know they want it because they filed it. And state's number 10. I put a question mark by it.
Right.
Now, since all the evidence has concluded, it does need to be tailored specifically for this one. And when I say tailored, I mean, obviously there's proposed language that state is submitted in parentheses, or I can just do it this way. Ms. Cross, since these are your submissions, let's just start with you. You want me to put, go ahead, Ms.
Which we are, the second full paragraph, the one that starts character for truthfulness.
That's correct.
I don't believe that there's been any testimony for or against any witness on their character for truthfulness.
Ms. Cross?
I agree with that, Your
I
Honor.
agree. So, Ms. Jeffries, that would not be lack of bias toward a party. You want that included?
Yes, sir, I believe
All right.
that would be.
I think that is.
So it'd be the first paragraph and the third paragraph, Ms. Jeffries. All right, that was on number 10. I had whole on number 11. That was the old impeachment of witness intact. Are you still pursuing this, Ms. Cross?
I think the only relevant paragraph, Your Honor, would be the first and then the bias toward a party.
I would agree.
All right, so first, the second paragraph, Ms. Jeffries, will not be given. The language that has been deleted at the bottom has been removed, so it'll be given with that modification. I had a hold on number 13, prior statements. Is the state still wishing this one?
Yes, Your Honor, I believe that there were several witnesses who were either impeached or attempted to be impeached by prior statements.
Ms. Petrie?
I believe that's appropriate.
All right, will give, 13. I had a question mark on 15, the intent. I was going to give the first and second, I'm going to use the term paragraphs, but it's a line in the second paragraph. The issue was the third paragraph. What's the state's position?
I think that's a correct statement of the law, and it should be given, Your Honor.
Ms. Petrie?
Your Honor, that is a correct, now, sit down while I address the board, if that's okay, so I can continue looking at it, we prefer me to stand, Your
I
Honor.
prefer for you to stand.
I will be happy to stand.
Thank
I'm going to
you.
stand right now. Your Honor, that is a correct statement of the law, but as requested by the state here, I believe that the caveat that some statutes require a specific intent needs to be given with it. This is correct as far as it goes, but it does not apply to all of the counts in this indictment.
Well, let me do this, Mr. Petrie. I know you have some specific requests on that. What about when I get to yours? What I will do is give the general, quote-unquote, intent as requested, and then identify those counts in the indictment for general intent, and then also identify the counts that require specific intent.
That would be absolutely appropriate.
Okay. Can we even now, lawyers, there are 13 counts, because that way we're on the same page, because no one want to be surprised. Mr. Pete, well, either side, Ms. Cross or Mr. Petrie, as far as on the general intent, what is the state's position on which counts do you want the general intent to relate to? Because I want to simply say, as it relates to counts X, Y, and Z, I'm not going to say general intent, but the intent will be given.
Right.
I think the only specific intent charge is going to be the hindering.
Which is number 1.
Your Honor, there's specific intent with respect to each of these statutes, and they are included in our pattern jury instruction, not pattern in the jury instructions, the rest of the charge that we submit.
Right.
For instance,
Go ahead. I'm listening.
on the perjury, and I think it was from the state's request that the false statement must be made with the intent to mislead.
Right.
That is a specific intent.
Correct.
So I believe on all the perjury counts it would be appropriate. On the false statement, you have to intentionally make a false statement.
Correct.
It's not just making a statement that is false, so I believe it would apply to that as well.
Correct.
On the hindering, by definition of the statute, it applies to certain parts of it. Now, there are, the complicating factor and the confusing part of this to me, Your Honor, is there are certain acts in each of the counts that just require the general intent.
That's correct.
But there are other parts that require the specific. I would simply ask the court, and I think as long as the court instructs the jury that certain counts require, as I will instruct you, a specific intent as defined by that statute, and then you will give that statute, I believe that that should
Would that satisfy you?
That would satisfy us.
Would that satisfy you?
Yes, sir.
All right. All
So
right.
we're talking about adding a line to what is state's request to charge number 15, saying certain counts require a specific
Specific intent.
intent. I will define the specific intent to those charges when I define those charges.
That is probably the cleanest way to get it to the jury.
All right, and we'll do it that way. And what I do, Ms. Jeffries, will craft that and let both sides look at that prior to 1 o'clock.
Thank
And
you.
make sure everyone's on the exact same page.
Thank you.
All right. I believe, Ms. Cross, that's the last one in yours that we were holding on. Nope, there's a note here.
Your Honor, we actually have some additional objections with respect to the states. With two of them I've mentioned with Mrs. Cross earlier. They are numbers 26 and number 27 of the state's instructions. The 26 and 27 are two attempts to cite the elements of a violation of 16-10-20. They recite the statute correctly. At the end, one says a person shall be guilty of concealment of facts. That's number 27. At the end of number 26, it says shall be guilty of the offense of false statements. The statute alleges different subsections, and they're not spelled out with A, B, or 1, 2, 3 in the beginning. But for example, on number 26, the state's request to charge, it ends by saying that the person shall be guilty of the offense of false statements. That is the second subsection, and what we need to delete there is everything after the word willfully up until the semicolon. So what would be proper is if we were to say a person who knowingly and willfully makes a false, fictitious, or fraudulent statement, etc. That's correct, but where it says falsifies, conceals, or cover up by any trick, scheme, or device of material fact, that goes to a concealment allegation, which is covered by the state's request to charge number 27.
So on 26, you want to read false statements in matters within the jurisdiction of the state or political subdivisions. A person who knowingly and willfully falsifies, conceals, or covers up, period.
No,
No, sir. It would read a person who knowingly and willfully, and then it would eliminate everything there until the word makes.
What's the state's position? Because they were basically just eliminating the word falsifies, conceals, or covers up by any trick, scheme, or device, a material fact. What's the
That
state-
goes to the
I
concealment.
understand.
Just count it up.
What's the state's position?
That's the way to charge.
You see the modification, Ms. Cross?
I do, Your Honor. Yes, Your Honor, we don't have an objection to that.
So it's going to read a person who knowingly and willfully
Makes it false.
makes, hold on, wait a minute. So willfully, there we go. Let's delete that language and we come all the way down to makes a false, fictitious, or you just want false only?
No, sir. Basically what we're doing is we're deleting everything between the word false, between the word willfully and the semicolon.
Correct.
So we're going to start with,
No, I understand that. We're there. Then it says makes a false, fictitious, or fraudulent statement or representation.
yes, sir, that stays.
Right, correct, that's what I was reading. That's fine, in any matter within the jurisdiction of any department or agency of state government or the government of any county, city, or political subdivision of this state shall, comma, be guilty of the offense of false statements.
Yes, sir.
All right, is that consistent?
Yes, Your Honor.
No, you got that, Ms. Jeffries? All right. Now,
Same thing with respect, I'm sorry.
no, go ahead.
The same thing applies with respect to number 27, Your Honor, except we're deleting the alternate language. So this one ends with the bottom, be guilty of the offense of concealment of facts. And so therefore, everything on the second line after the semicolon, after the word fact, should be deleted. So makes a false, fictitious, or fraudulent statement or representation.
All that should be deleted.
Yes, sir.
Correct. And it will read, concealment of facts, matters within jurisdiction of state or political subdivisions, a person who knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, The language deleted comes down to any manner within the jurisdiction of any department or agency of state government or of the government of any county, city, or political subdivision of this state shall, be guilty of the offense of concealing the facts. State agrees?
No objection.
All right. That'll be modified. Anything, now we were holding on, well, I was holding on because we didn't know whether your client was going to testify.
Right.
She decided not to testify, so any objection 28?
I don't think it's necessary, Your Honor.
So you withdrawn?
I'm withdrawing,
No, you're right to withdraw it. That's all I need to hear. Withdrawn. Because the defendant did not testify. Okay, number 29. Did you say you had any other exceptions you want to put on the record?
No, sir.
Okay, so that's all of the states.
Not the states.
Okay. Is there any additional state request for charge?
no, Your Honor.
Wonderful. All right, let's turn our attention, Ms. Jeffries, to the defense request for charge. We're holding on, and Mr. Petrie, if you could, which one, the first one we're holding on yours to come back to? We had 49, and we've gone through the majority.
Right, and I was doing
The
it.
first one I have is number 12. I was holding on 12.
Right. That's covered by one of the states, number 12, defense rule 12.
Defense 12, any objection,
We-
Ms. Cross? I think it's covered already.
We've covered this, and we've already made modifications to their request, so we will withdraw this one,
Okay,
Your Honor.
their 12 was withdrawn. Okay, and number 13, we're just going to give that, for 13, the last paragraph says the credibility of the witness may be
Right.
attacked by disproving the facts to which the witness testified. Let's see. I was holding on 17, defense 17,
We do request this.
and the state has no objection because
No
she did not
objection.
testify.
Yes,
And now
sir.
the language that's going to be listed here, the defendant in a criminal case may take the stand and testify and be examined and cross-examined by any other witness.
Is that what you want?
No, that's not what we want.
You don't want that one, do you,
No.
Mr. Petrie? I was okay, so you don't want that paragraph?
No,
Mr.
sir.
Petrie? Okay. So you just want the last paragraph, Mr. Petrie?
And, right, and last paragraph, scratch out however.
That's correct. I was going to say, okay. So this, so Ms. Petrie, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision.
Yes, sir.
Any objection from the state?
No, sir.
Wonderful. With that modification of deleting however, we'll give Ms. Jeffries on 17? All right. Number 18, Mr. Petrie, this is yours. It says good character of defendant.
I don't think we actually had technically
you
good
didn't have
character.
good character witness.
I think we had
I understand, but you didn't,
habit and routine. I saw,
correct, you didn't have.
let me confirm, Mr. Clay's calling
Well,
outside.
he's outside working on his closing, but,
I do not believe that that
You're
is
gonna withdraw?
appropriate. Yes, sir.
all right. If it's withdrawn, 18 is withdrawn. And I'm assuming the state has no objection when he withdraws.
We do not, Your Honor.
21, this is what you did have.
Yes, sir.
Any objection to 20? That's why I was holding on because we had not gotten to that point.
I do object to that, Your Honor. I don't think there's a basis in it.
You may consider that. I'm sorry, say that again? You say you objected because what? I
I
heard
don't
what
think
you
there's any
said.
evidence of habit, routine practice.
I think we had lots of that, Your Honor.
Yeah, I'm gonna give, yeah, I understand what you're saying, but from an interpretation standpoint, I'm gonna have to give that one. We'll give overstate subjection, Mr. Jeffries. So 21, we'll give. Let's see, 23 would not give, well, I don't know, you don't make the ones that I'm calling on. And a question mark on 27. This one you want?
May I interject if we're going to go ahead to the other ones, because count 24, like the record to reflect, the defense does in fact want 24 in.
No, I know, I mean, I put all that, I mean, that's been noted, I mean, I'm not giving. Mr. Petrie laid the, he put his objections on.
I just want to be clear, I thought that John might have said yesterday, Mr. Speaker, that we were okay with not including that as long as it's included elsewhere. I don't believe it is included elsewhere. It is an element of the defense. And I want to make sure that the record reflects that the defense requests that be charged.
Okay, we're not give, it's noted. All right, now, Mr. Petrie represented your side very well. Number 27? What's it, you said, this is the one, Ms. Cross, you want me to come back to?
This is,
Defense 27.
defense 27. Yes, Your Honor, I didn't think
You
that
mentioned it
was-
late yesterday afternoon, and I told you we'd come back to it.
We did, and I can't remember now why.
So, does that mean you have no objection? That's all I need to hear.
No, I do object to that, Your Honor, for the original reason, not the second reason I came back to it. I do because I don't think that is, one of the charges is concealing facts, and I think that silence or non-disclosure is not an affirmative act. I think that is Contrary to the case law, I think that would not be, it's not tailored to the facts of the indictment in this case.
Your Honor, I respectfully disagree with that. It is actually supported by the case law. There is a Fifth Circuit case, 1977, the United States versus London case, which very clearly states that mere non-disclosure is not an affirmative act. It is not a trick, scheme, or device for purpose of the federal concealment statute. That was subsequently cited and relied upon by the United States Supreme Court in the Woodward decision, also interpreting the federal false statement and concealment statute. There are Georgia cases,
Yeah,
including...
I don't mean to cut you off, but the way it was working, Mr. Petrie was I was listening to one lawyer at a time. Now, I understand you guys can work in concert, but actually, no offense, but are y'all handing off? Who's representing the defense on these issues? Mr. Petrie or Mr. Chalmers? I just want to know who I'm listening to.
You want to,
Sorry. Go ahead.
if the court would like to just hear from one of us, I will defer to Mr. Chalmers from here on out.
Okay.
That's what I'm inferring that from the court. You won't want us to choose.
Correct.
We-
Mr. Chalmers? Yes, sir.
Your Honor, there are just a couple of the charges where I'm prepared to testify based on the legal authority on what happened yesterday. With respect to charge 27, the request is that the charge, silence is not an affirmative act, be included. The London case and the Woodward case have been included.
Let me respond this way. I will give over state's objection unless you want to talk me out of it.
I have nothing further to add, Your Honor.
I mean, that's why I was trying to see what I'm listening to. I was going to give it, but, so, okay, I
Nothing
will
further, Your Honor.
give over state's objection. We'll give, Ms. Jeffries. I just had a question mark because I want to hear from both sides.
Thank you, Your Honor.
All right. Are there any other question marks? And I know, Mr. Chalmers, for whatever reason, you were not here yesterday afternoon, and we've gone through all of these, and there was only some exceptions that I had put question marks about it. I want to hear from the lawyers.
I don't have any other that,
I don't have anything else. And the idea was, I mean, and I don't want to limit you, but that's why we spent an hour here yesterday afternoon.
Your Honor, I understand, and I have very little else. The one case, Your Honor, if it's helpful to have additional citations in support of it, charge number 38.
Charge number 38. Let me go back to 38.
That the corroboration must be strongly corroborative. I watched the testimony. I watched the hearing last night, Your Honor, and the state objected, stating that that was not an accurate summary of the law. This is the interest of CH case, Georgia Court of Appeals, August 2003. That is the relevant quotation down highlighted there, which states the corroboration for a perjury conviction must be strongly corroborative. It cites back to a 1909 case which establishes this has been the law in Georgia for over 100 years, was reiterated in 2003. So I'm happy to give the case to Your Honor.
Oh, I'm happy to have it.
May I approach you?
You may.
On the second page.
And I said, I'm just looking at, is this the last one we're dealing with?
Yes, sir.
All right. What's the state's position?
Your Honor, I maintain that while there is some language in that case law, there is language in the other case, Dixon, West, I believe is the other one that is, excuse me, is contrary to it. And so the wording that we have agreed and is going to be submitted with no objection covers the topic of the cooperation necessary. The jury will be informed in the pattern instruction that generally the testimony of a single witness is sufficient. In cases of perjury, some cooperation is necessary. That's accurate, that's complete. The charges, as we've agreed to be given, covers the topic, and the state continues to object to defense request number 38.
Let me take a look at your recent case, Counselor.
Yes, sir.
I do have a copy, Your Honor, of the case I'm citing, Dixon versus the state.
Well, you may, I thought you gave it to me already, but if you want to bring it up again, bring it up.
I did.
Let me take a look
Just
at
for
it.
recency.
Because I mean, the distinction is, I mean, the language he wants, and I understand, the corroborative testimony must be strongly corroborative of the testimony of the other witnesses. It must be such a character that when taken in connection with all other testimony, the falsity of the testimony is established beyond reasonable doubt. No, I understand. Let me see what you have. Thank you.
Your Honor, when you're ready, if I may address Dixon very briefly.
You may.
Your Honor, Dixon doesn't say anything contradicting the case that I gave to you. Dixon's also an older case than In Re CH, which is 2003. Dixon's 1984. All that Dixon says is that a conviction for perjury requires either testimony of two witnesses or that of one witness in corroborating circumstances to support it. That's just a recitation to the statute. The proof that the defendant had made contradictory statements is not alone sufficient to convict. We actually have relied on that principle with respect to a number of the counts. Moreover, in perjury cases, when we speak of corroborative evidence, we do not mean evidence that emanates from the mouth of the defendant himself. That's effectively stating the same principle. I believe that the portion of the language of Dixon that the state is relying on here is that the determination of the weight and sufficiency of the corroboration is a matter for the jury. Every element is always a matter for the jury. But in the previous cases, since 1909, and the more recent case after Dixon, which is the In Re CH case, the court made it clear the corroboration must be strongly corroborative in order to convict somebody for perjury. So we respectfully suggest that Dixon is not contrary to the authority that we gave to you, Judge.
All right. Well, I understand, Mr. Chalmers, as I indicated last night, I understand you had reviewed apparently the tape. I'm going to stand by my ruling. I will not give, and exceptions noted, and obviously yes, I understand, it's noted.
Thank you,
But I
Judge.
will not give as indicated last night, and thank you for the supplemental cases. Any additional requests for charge may be reviewed?
Not from the defense, Your Honor.
Not from the state, Your Honor.
All right. One quick thing. Mr. Jeffries has given me a note. Look back at, well, Mr. Chalmers now, the state's request number 6, because it needs to be tailored to this particular case, Mr. Petrie, who started last night. What deletion, because this is on the stipulated facts, Lord.
Yes, Your Honor.
It says the parties have entered into a stipulation that has been approved by the court about the following, because I know there was Mr. Chalmers, I know you're involved also, but there was a written stipulation, the lawyers were going to draft it.
I think each of those items were in some way stipulated to throughout the trial. There was the testimony of Mr. Kirschenbaum, there was the phone records and the exhibits, as well as the emails and the authenticity of some. So I think it's covered by facts, testimony, documents, and exhibits.
So it should be approved by the court about the following facts, testimony, documents, and exhibits.
Yes, sir.
It normally wants me to specify, so
I think it might streamline it if we just mention here any stipulation, like the stipulation about Mr. Kirschenbaum, that doesn't go back with the
Correct.
jury.
Correct.
It doesn't.
And the records that we stipulated to, they would go back.
That's my belief.
BlackBerry would go back.
correct.
That's fine.
I think really that
There were several DVDs and other tapes that
just the
would go
authenticity.
back.
Right, correct.
So insofar as what this request to charge would cover, I mean, do you really want it?
Do I really want this?
Yeah.
Well,
Is that gonna-
well, first of all, you got stipulated facts, so you're gonna have some version of it. Because,
They need to know what to do with it.
Fact we had, I think it was Mr. Kirschenbaum.
correct, but
Well,
you
there
don't want them to disregard things that you, well, I'm not telling you what to do, but
Right.
you really don't, so you really want this, well, I know you asked her, she didn't respond, but you want some version of this.
The state requests the charge be given.
All I need is, what do you want in the, for the lack of a better term, the list, that's all I'm asking. Because I don't want it to sound as if I'm making a comment on any particular thing. I'd be more than happy just to say the parties have been into a stipulation that has been approved by the court about the following facts, testimony, documents, and exhibits, and don't say anything else, if that's what you want.
We could even do just certain facts,
About certain-
testimony.
Right.
But it really requires me to specify which ones they are, that's
Yeah.
what I was trying to get to.
Okay, I mean, we have a written stipulation that I think we're happy to add Mr. Kirschenbaum's testimony to, and that, from the state's perspective, is sufficient.
Right.
Okay.
And even you had one other thing you wanted us to sign. There was a simple one that we got. But
You had the phone records?
So.
We'll-
in
we'll
that
talk
list-
over it, yeah.
Right, but actually, we need to do it now, because when we come, because the lawyers technically
Right.
have to know what's going to be given before they give their closing arguments.
I mean, we stipulated to,
you brought in the second one that you. Now,
Yeah.
You may.
get some of this stuff. Would you have a stipulation?
Like I say, now, if both sides agree, if you don't want me to specify what those are, I don't mind, as long as everybody
yeah,
understands. it's
if
gonna
he
be-
agrees, I'm okay with it. If the defense agrees, I'm okay with that.
I'm fine with that too.
All right.
Because I think everything that was stipulated to was identified at the time. It was just so certain facts, testimony.
So the word we're adding, Ms. Jeffries, is
You think we should?
following certain facts, testimony, documents, and exhibits, period, and then I will read the rest of that body. All right, and the other issue was on number 11, Stacy 11. When everybody's free to stay, we're just going through, this is what a charge conference looks and sounds like. Please repeat what was okay. On number 11, just want to make sure we're on the same page. I will get the first paragraph.
With the exception of the,
The second paragraph would not be given.
in the first paragraph, the parenthetical phrase would not be given.
Correct, will not be given. Correct. And then the second paragraph will not be given at all. The third paragraph, bias toward a party shown by bad acts, extrinsic evidence of cross-examination, specific instances of conduct of the witness in question that may relate to the witnesses in question is biased toward a party. I'll just read it in its entirety, and nothing else will be given. Okay? So now, those only questions Ms. Jeffries had, any other, just want to make sure we're on the same page. So see, once we break, we're going to be back at 1 o'clock.
Don't say, did Ms. Jeffries understand that what we're requesting is in the first paragraph, that parenthetical charge only those that apply be withdrawn because there is only one in this case?
Correct. You understand, you follow Ms. Jeffries?
Yeah.
If I'm not,
On number 11.
About service, testimony.
Okay? You may want to say it out loud so Ms. Cross can hear and make sure we're on the same page.
scratch through, charge only those that apply.
Gotcha.
Right, that won't be given, Ms. Cross, and this is on your request.
I
So it'll be the
think
first
that's correct.
paragraph with the exception of what's in the parentheses, and then this third paragraph down. I will not read the code section, but all the other information.
Yes, sir.
Okay.
We're in agreement.
Okay. Anything else? I see,
Yes, sir.
because we're going to, you sure?
You sure? You sure? Yes, Your Honor.
Okay. Mr. Chalmers or Mr. Morgan, anything on the charge? Anything else we need? Mr. Chalmers? I don't want to leave you out.
Your Honor, the only thing I would note is that the jury instructions will now state that silence is not an affirmative act, but it does not link up that with the trick, scheme, or device requirement, because charge number 31 requested by the defense is not going to be given. The trick, scheme, or device language, Your Honor, is straight from the statute.
the Marcus case holds that a trick, scheme, or device must be an affirmative act. The instruction that silence is not an affirmative act is in fact what is now going in because it is the
But
law.
I'm giving you number 27.
Number 27.
I said I will give it.
I think
It
that,
says silence or non-disclosure is not an affirmative act. That's what you want me to, I said I was going to give that.
yes, sir, but in order to link it up, silence or disclosure is not an affirmative act. We have to explain to the jury why an affirmative act is relevant. The charge that does that is number 31.
State renews its objection to charge number 27.
No, well, I understand, it's noted. But I was going to give 27, but I said I'm not giving you 30. Yes, I understand, Mr. Jones.
Okay, thank you, Your Honor. Nothing further from...
All right. Anything else for the record?
No, sir.
Right now? All right, Deputy Garrett, we will be on recess until 1 o'clock, lawyers. And if you could, I know your lawyers who are doing closings, if y'all please update them on what will and will not be given, please. We will do that. All right, thank you. All rise.
Anna, we're being paged.
So here we are. We are making our way now toward the end of this. As you look at Andrea Sneiderman, the lunch break is forthcoming. I'm Jeff Hullinger, along with Zara Karinchak, who is with us. She is a former federal prosecutor, a defense attorney, a graduate of the Air Force Academy in Colorado Springs, Colorado. She has led an amazing life, and we appreciate you being here and sharing with our viewers some of the insight